So this is LAWS 13013, Legal Professional Conduct. The week is number 2, and we're looking at tutorial problems 7 and 8. All right, I'll just stop that. So there was just a comment before we started recording about setting up your assessment 3 groups, the teams, and you can do that via the assessment tile under assessment 3, and you can select the group and you can see who's in it. So that's supposed to be done by the 18th of March, which is tomorrow. So thanks for bringing that up. So it's just a reminder there for people to do that. All right. So we've got a couple of problems this evening. They're very interesting problems, I might say. I hope you gave some thought to them, because they're very practical issues, as we'll see. So let's get into the problems and see what you think. So the first one is, what features of the legal profession may create a negative image of the profession in the eyes of the public? Is this possible public perception a reasonable view? And then find some examples of advertising. This is a really fun bit. Find some examples of advertising by lawyers and the perceptions that that might create. Then how can lawyers improve their image, etc. All right, well, let's have a talk about what features of the legal profession can create a negative image. So what sorts of things create a negative image for the profession as a whole?
I'd say basically one of them would be the self-regulation part of it, the high cost involved in getting legal advice, and also the fact that with legal professional privilege, certainly there is scope for things that aren't above board to sort of go under the radar.
Yes, on that issue of legal professional privilege, there's a case going through the federal court at the moment looking at legal professional privilege, which has been claimed by lawyers who work in accounting firms, major accounting firms. So that's going to be a major judgment that we're expecting to come out and most likely go to the High Court fairly soon. So that whole area may be reviewed. So that's certainly legal professional privilege does create some skepticism because not everybody has this privilege, and those that don't would love to have it. So that's certainly a factor. The high cost of lawyers is another feature. And when you look at the cost of lawyers, compare them with the costs of accountants in those larger firms, they're fairly similar, quite expensive. Even first-year law graduates can be charged out at hundreds of dollars an hour. So that it's quite an expensive process. And when you get to civil procedure, you can see the costs that are talked about in that unit. It's tens of thousands of dollars to get into court, and really you should avoid that at all possible. All right, what other sorts of issues? So there's a few there, but there's lots of them. What other sorts of issues create a negative impact?
Well, there's always the public view. People don't understand what goes into being a lawyer or within the law system itself. They watch a lot of TV shows, and hence their public image is from, oh, your job's to get me off. That's what the public view is built from social media, not from actual real life experience.
That's right. People's exposure to the law only comes about when they have some sort of transaction, day-to-day transaction, like a conveyance and what have you, or they fall foul of the criminal areas, and generally, if they do go to court, they find it's an horrendously expensive process. And you're right, most of the perceptions are coming out of the media, social media, or traditional media. And they don't know what lawyers do, because a lot of people just aren't exposed to what lawyers do. That's true. All right, what else?
Ambulance chases.
Yes, ambulance chases. I saw an example of a lawyer who actually, in effect, had an ambulance, which is a new twist on ambulance chasing, who actually lives just down the road from me. But anyway, it's another story we'll get to. Yeah, ambulance chasing lawyers. And we'll look at the advertising rules in relation to that a little bit later, because they're quite strict, because it's a phenomenon. that they've had to regulate. All right, what else?
I think the fact that lawyers also do have to go into court and defend people who've done some pretty horrendous things, and then also have to cross-examine people who garner sympathy for what they've gone through.
Okay, well, there's a few things there. Firstly, solicitors don't have to do that. The barristers may well have to do that because of the cab rank rules. So there is a difference between the branches of the profession about the necessity or an obligation to represent, repugnant clients. But yeah, certainly there can be a stigma attached to a lawyer who represents repugnant clients when we do know that we're trying to preserve a system that everybody has a chance for representation and a fair trial. And there's a lot of issues surrounding that, which we'll look at later in the course. All right, what about the language? I mean, you've spent quite a while studying law now, and you've been learning all sorts of language. So it's got its own language, and that's a form of exclusivity in that people don't, lay people, I'll put it that way, don't necessarily understand the language. And one view on that language is that it's a form of exclusion, that you're trained to understand that where others aren't, and you gain an advantage by having that knowledge. So complex language alienates people, makes them feel powerless. So that's an interesting thing to think about, which have probably never even thought about because you've been doing it, been studying law and picking up this language and way of thinking throughout your particular course. I'm not sure the F word is the language we're referring to there, Tim, but I had a boss like that once. In fact, I had a boss, he actually tore up a client file in front of me, and he threw a chair into a window on the 27th floor of a building. So some of them can be quite heated. I've seen situations where clients have actually started fighting in mediations. All sorts of things go on. But some of these things can be, firstly, can attract quite abusive personalities or strong personality, put it that way. And, it can be quite heated. All right. What other sorts of issues can people think of? We've covered a lot there so far. Any ideas?
Law sometimes doesn't, when you're representing someone, it doesn't seem like it's justice. So the lawyers default to blame for that, using loopholes to get their clients out.
That's right. One of the ads I'll show a little bit later, it's sort of, just because you did it doesn't mean that you're guilty. But yeah, that's right. And I mean, lawyers are paid to represent their clients and to suggest ways that you can avoid penalties and other sorts of problems, I put it that way. Okay, what about this whole issue of access to justice? Have you got any thoughts about that?
Well, a lot of people take a more moral view about justice, right and wrong, generally based off some social aspect, when law is not necessarily about justice for a lot of the points. You're not there to perform a justice, you're there to perform a service.
Oh, I've got a good story about that. I had a job as an associate once for Justice McPherson in the Supreme Court many years ago. And when he was the senior puisne judge sitting on the Court of Appeal, we had this fellow came up. Yeah, he was huge fellow. And anyway, he was self-represented. He was appealing against a conviction and sentence on 2 counts of murder. And he starts off, and his first statement he said, "Is this a court of law or is this a court of justice?" That's what he said. And I remember Justice McPherson looked at him and said, "This is a court of law." So it's a court of law. It's not necessarily a court of justice. So that's an important thing. There's a distinction. All right. Okay. Any other thoughts? Well, just on that access to justice issue, I was really trying to get you to think about the idea that it's a lot easier if you're rich to have access to justice than if you're poor. If you're poor, you're really behind the 8 ball. You're stuck with trying to get legal aid, which is pretty scarce. Maybe you'll get a pro bono lawyer to represent you. We have endless people contacting us wanting legal advice, us in terms of legal academics, just out of sheer frustration of the lack of services. Yeah. So, yeah, it's a very sad state of affairs. And, you know, there's various potential ways to try and solve those problems. Technology is one. Trying to educate people is another. So you see in some of the countries like in British Columbia, in Canada, they have bodies that are funded to provide legal education to assist self-litigants. We don't really see so much of that here, but it's quite a big thing in some of the Canadian jurisdictions.
Quick question, Stephen.
Yep.
Does that mean there's not enough lawyers in the profession?
It's not the case necessarily that there's not enough lawyers. It's just there's not enough lawyers who want to work for nothing. I think that's what the problem is. That you know, people who don't have the financial resources to pay the normal rates of lawyers aren't going to necessarily attract somebody to represent them. You do see pro bono work, and you do see free pro bono and also reduced fees, and other sorts of schemes like no win, no fee, that sort of thing. And we can look at that a bit later. But there's plenty of lawyers, but you know, people don't want to necessarily work for free. That's a problem.
How about diversity and representation? A lot of times the communities that are underprivileged or marginalized may not have the adequate representation in branches where the law is either made or applied or interpreted.
So this goes back to that, what we were talking about last week about sources of power, where the power resides in society. It generally doesn't reside with marginalised groups. Although we're now seeing an interesting phenomenon with First Nations people gradually gaining more and more power. If you've noticed, if you go back, you know, 15, 20 years ago, you wouldn't have seen the same sorts of power being displayed. That's interesting.
I think there's a lot of pro bono work done in immigration and refugee cases too, isn't there?
There is, because humanitarian law and that sort of area is popular. Whereas if you compare that with another sort of area, say domestic violence, are there as many lawyers representing people in that situation as in the migration cases or humanitarian cases? Don't know. But you know, I think what you'd find is that certain areas are more attractive to lawyers for pro bono work than others. All right. What about delay associated with lawyers? I mean, a classic one is in relation to things like succession law and dealing with wills and finalisation of estates. Now, there are rules about lawyers not delaying, but those things take forever to sort out. It takes a long time. So one of the negative aspects of the perception of lawyers arises from delays. And it might be delay in the court system, and might be delay with the lawyer and dealing with all the files, or just delay in, you know, the amount of time it takes to do things. So delay is another aspect of this. So cost, delay, access to justice, they were the three pillars of civil procedural problems. It's the same issues with the ethical problems as well. Okay, what about class actions? What do you know about class actions?
Very expensive, and you don't get much out of it at the end.
They are very expensive, but what was the rationale for having them created in the first place? Why do we have rules in relation to class actions?
Putting together so many of the same case into one case means that everything can be litigated at the same time.
That's right. And more than that, it's usually a situation where the individuals in the class wouldn't have the financial capital resources to be able to run the action by themselves. So what they do is they band together. Usually it's a litigation funder behind it, and a law firm putting up, we will create the class. You can, you know, opt in to be part of the class. and then the class action proceeds. So it might be, on one hand, a positive note, an opportunity to gain some form of redress that wouldn't otherwise be available because of the cost. But on the other hand, large percentages of any potential recovery go to the lawyers. And that's been one of the big bugbears about this sort of class action situation.
I'm sure we're going to talk about this, but there's been quite a few class actions that have gone through the courts recently in relation to COVID and the Public Health Acts. And the way that those class actions have been run by using GoFundMe type of public funding, and then also attempting to get multiple litigants to sign up. I think it's different to your standard class action where you have a representative of the class that
Right.
you kind of end up representing the whole class, and then everybody can apply to get a portion afterwards.
I think it's a difference in the funding. I mean, the GoFundMe is a distinct source of funding. A law firm taking the risk is another form of funding. And then there's the litigation funding corporations, if I put it that way. So the GoFundMe is another variation on the source of the funds, but ultimately they all have to still operate within the class action rules. And in the states that have class action rules, not all do, or within the representative rules for those states that don't have that. So they still operate within the same framework. It's just a difference in the funding, and it's there's a difference in terms of who's actually controlling it. Yeah, that's interesting. We talked about the popular culture on the TV that often demonizes lawyers. So I think we've covered most things, so that's fine. Excuse me. So why don't we have a look at part 2? Did anybody find some examples, some really terrible examples of lawyers advertising? There's a lot in the US, but there's a few in Australia as well. Did anybody come across any examples they'd like to share? Looks like you've got one.
I've been following one for quite a while, and it touches on that GoFundMe type stuff. And I'll mention the law firm because it's on the public record now. Mm-hmm. And it relates to the anti-vaxxers and those opposed to the vaccine. And there was a law firm called G&B Lawyers and a representative called Nathan Buckley, who was advertising on Facebook. And it was advertising to get people to go to the GoFundMe site to fund these court cases to enforce the Nuremberg laws and all the other fanciful things that were being discussed. So I went to the GoFundMe thing to have a bit of a look, and there was 800,000 had already been contributed. And if you go to contribute, down the bottom of the page, it said, if there's any money left over after this case, we won't be able to disperse it because you're all voluntarily contributing anonymously. So basically, they were going to keep anything that was left over from it. Now, Nathan Buckley, the solicitor, found himself in trouble with, I think, the New South Wales Law Society, and was told, I think, because as this story progresses, you'll understand why. I think because of the GoFundMe thing, he was told you can't do it, I think. So I was on the Facebook page, and he then said, I've been charged and they're trying to strike me off as a solicitor. I've opened up another GoFundMe case so you can help me out there. $300,000 got contributed there. And he posted the charges against him as a solicitor on his Facebook page, but he only posted the very first page. So all I did was put a comment on there that said, can you post the other pages of the charges? I'd like to read them in full. And I was blocked from making any further comments on the page for just asking that question. So these questionable practices and stirring up the anti-vaxxer crowd to hand over money for court cases they're never going to win, I think is a really poor means of advertising, and he's now been struck off for 12 months.
He also threatened the judge and got people to threaten the judge as well. Yeah, I was following that as well.
There's also rules that you're not supposed to bring litigation that has no reasonable prospect of success. So some of the court rules have that written into them. So yeah, there's all sorts of problems with that case. Yeah, so thanks for raising that one. What other ones have we got? Come on, there's oodles of examples of these things.
Yeah, I just put up one. It was I googled it, lawyers in Brisbane and Warlow Scott. They have a massive page of all the community support that they do and all the charities that they support, and it was quite impressive.
But that's a positive thing, isn't it? That's not a negative.
Yeah.
So that's,
No,
that's,
oh no,
that's on
sorry.
the
I
other
thought
side.
we were
Yeah.
looking for positive. Yeah. sorry.
No, the negative one's much more fun. The positive ones, yeah, you're right. We'll get to the positive ones, so that's good. There is a countervailing in here, but let's think about some more of these negative ones. I mean, I'll share my screen here. I've got some examples of ones that I love. The American ones. Look at this one. This is on an elevator door. So it's got a couple together, and then the door, it parts, and then you got divorce lawyers. Sorry. That's pretty bad, isn't it? Then there's this one. Buy one divorce and get the next one half off. Cheap divorces. I saw one. It was a beer coaster, actually. And so he goes under the glass of beer at a hotel. And when you get to the bottom, it says, basically same sort of thing, all about divorce. If you're having problems, come and see us. That was on a beer coaster. There's some other examples here. These American ones are terrible. I mean, look at this one. And this one here. So there's your, hopefully not your typical Harvard Law graduate. There's some terrible personal injuries on it, mostly about personal injuries. And this one, I got a different angle on getting a divorce. This is an interesting one. Just because you did it doesn't mean you're guilty. And that's actually true, but it's an interesting way to advertise your services. So what would be an example where somebody's done something that doesn't mean they're guilty? So what's this ad trying to get at? Think back to your criminal law studies years ago.
It would be if you were, say, charged with murder and then you it was reduced to manslaughter or something like that.
Well, that's right. So you may not have had, the intent that's necessary. You don't have all of the elements that's required for a particular offence. Sorry, Steve, you going to say something?
Self-defence.
Yeah, self-defence. That's right. So it's accurate.
Lack of evidence.
Lack of evidence is another. So Erin Brockovich, that was an interesting one. So Shine Law was using Erin Brockovich for a while. What do you think about that as an approach? There's actually nothing wrong with that, is there? But it's a form of
They fight for fair.
Fight for fair. Well, it obviously worked. You've remembered the logo. But yeah, so it's the use of celebrity as a form of marketing, which is, I suppose, what about this one? That might be problematic depending on where you park the bus. Why would I say that?
Because you're not supposed to be near a hospital or
That's
medical
right.
centre.
That's right. That would be problematic if you parked at a hospital or outside a hospital. It may not be problematic in other places. So there's
Would
It
it
might
be
be such a
seen
distraction
as-
that it caused an accident.
Yeah, could it be seen as like vulgar or like put the profession into disrepute for advertising like that?
I don't know why would that bring the profession into disrepute?
Well, chasing ambulances and looking for people with injuries.
They're not necessarily chasing an ambulance. I mean, chasing an ambulance is literally chasing the ambulance, being at the scene, handing out your business card, somebody who's injured, slipping it in their pocket, following them into the hospital. I mean, all this has been done. People have been known to do these sorts of things. No, I'm not sure that one would be problematic. What about this one? That's a strange ad, isn't it?
Well,
Yeah. Sorry, I really like this one though. An honest attorney, but not enough to hurt your case. It's not a classic. So I think that one's borderline. It's problematic. This other one's just a bit crass. Same with this one here. I hammer insurance companies. Well, okay. That's another form of advertising, pulling sort of the heartstrings, but it's not probably, it is true, but it's an interesting slogan. Look at this pair. Yeah. It's probably okay. These ones, guilty of anything, probably boredom more than anything else on the tax issues one. That's probably okay. Anyway, so there's, oh wait a minute, there's another one. No. Well, what can we say about that one? So there you go. So there's a few, mainly American. You don't really see that many bad examples in Australia, not to that extent. Obviously, the market in America is a lot more cutthroat and aggressive and in your face. So,
are there rules around advertising that prevent it to happen in Australia?
Absolutely, we're going to be looking at those in a little while. So, what we'll do before we do that, look at the advertising rules. Let's go back to the positive image, so we don't have the one size. Well, I'll get Wendy to restate her position. So she found a good example.
I did. I stuck it up there. It was Warlow Scott, and I had a whole page just to show all the community things that they do and services that they provide and how wonderful they are and trusting, and yeah, I gave them a good rap.
Yeah, that's right. So some of the positive aspects are really tackling the fee issue, fixed fees for defined work so that you haven't got a sort of open-ended scale, sponsoring community and sporting events and other activities, a high profile around pro bono work, and having a solid relationship with clients, and having a client focus and providing good service and value for money, service on boards, community boards and other sorts of things like that, scholarships for students, all sorts of things. Yeah. Yep.
If you have a friend who recently had, say, an accident, and you contact them saying, "Hey, can I represent you?" Is that unethical?
So they've had an accident, so they're a friend.
Yeah, you contact them while they're in hospital.
It's probably not a good idea. So I would suggest in that sort of case that you avoid that for a couple of reasons. One, they're a friend. It's probably better to keep them as a friend rather than as a client. Secondly, you shouldn't be approaching people in hospital, as we'll look at the rules around that. But generally, I would suggest you get them to see someone else. So you can assist them to the extent that someone else represents them. And that way you'll retain your friend.
I'm not asking personally.
That way you retain your friendship. Because, things can go wrong in litigation. If it goes to litigation, it's expensive and it can, I would avoid all of that if I were you.
Yeah.
I think so. What do other people think?
Actually, I was looking through the Queensland Law Society webpage today, and they've actually got an area about if you want to represent your friend and things that you shouldn't do. And yeah, it was really interesting.
So do you remember what they said?
I printed it out and I can't remember.
Can you send me the link?
But
I think it's very
it was
important too,
not
if you're a
advisable to.
criminal- I think if you're a criminal lawyer, you
I'll
don't
find
need
it. Their website is really good. There's so
Okay, so what we should do is see if we can find that, and then if you have a look for that, Wendy, and then post it onto the chat, or if someone else has noticed it, so that'll help Stephen there to deal with his issue. But my general thoughts on that is to avoid that problem. But I'm totally risk averse. So you're probably asking the wrong person.
And especially if you're a criminal lawyer, you don't need to be
Just for
talking
clarity.
to your clients.
No, just for clarity, that issue was actually an issue that that a friend of mine had just recently happened. A friend of hers had called her while she was in hospital after having being hit by a car while she's training on her bush bike, and he's a partner in a law firm, and asked and said, I'll represent you if you want. And yeah, that's all. I just thought it was.
It's best not to see. One of the other problems is family is always another area where, you know, a member of the family, or close or otherwise, will know you're a lawyer, and then suddenly you become the source of all questions related to the law. So if they have the problem, often it's better just to avoid that conflict, because you can lose your objectivity, and that's a real problem. So it's better to refer them to another lawyer that you know, and vice versa. If the other lawyer has a problem, it's a better way to deal with those sorts of issues. And especially at your stage, because you won't have practicing certificates, so you shouldn't be giving legal advice anyway, because that's an offence. Well, not an offence, it carries a penalty. So that's another issue to avoid, at least until you get a practicing certificate. All right, what other positive things can lawyers do? Any other ones we can think of?
pro bono work.
Sorry, somebody cut out then. Who was saying that?
Oh, sorry,
Oh,
pro
Wendy.
bono work. Yeah, pro bono work.
Yeah, pro bono work. I did mention last week, I think, didn't I, that Queensland had the lowest rate of pro bono work in Australia, which was interesting. And that there's a study looking into why that might be the case at the moment, and to try and do something about organising a better outcome for people in Queensland. But certainly sponsoring charities and fundraising events, all of those sorts of things are examples of a positive image. But I think the best positive image is actually doing a reasonable job for people at a reasonable price and in a timely way. Because at the end of the day, somebody's come to see you with a legal problem, that's what they want. They want a good service and, you know, a good outcome. And if we can achieve that, then we'll go a long way to building up a positive perception of the profession. Okay, so that's enough on all of that. So let's have a look at problem 8. Problem 8 is really useful on this question was about what are the advertising rules. So we've got an example here of Murray Stacks, the managing partner of Stacks, the law firm. And he's considering advertising strategies to build his personal injuries practice, and he wants to build a new practice in migration law, which is an area that he has no current expertise at all in his law firm. Okay. Now, Murray's concerned with the ethical standards of his firm and asks you to advise him on the ethics and legality of the 6 strategies, or 7 strategies, I should say. So I added an extra one. 7 strategies in your advice and give reasons. So let's have a look at each of these in turn. So the first one is leaving business cards in the reception and emergency sections of the local hospital. Okay. What do you think about that?
You're not allowed to under section 65(2)(b) of the Personal Injuries Proceedings Act 2002. That is, you can't release leaflets to the hospital.
That's right. There's a very specific legislative provision preventing you doing that. Okay. So what happens if you ignore that? What's the consequence if you're prosecuted?
Is it misconduct?
Potentially, but there's a specific penalty. It's a 300 penalty unit fine. The penalty unit, last time I looked, was like about $120. So it's a reasonable sort of fine for doing something like that. So what we should do is, I might just put up the, I've got the sections here. Yes, I do. Just let me put this up and we can have a look at the share screen. Okay, let's make this a bit bigger. All right, well, let's just go through this slowly. So this particular act, the Personal Injuries Proceedings Act 2002, Section 64, let's start there. This is the meaning of advertisers' personal injury services. So any of those penalty provisions, you've got to be advertising personal injury service. Okay, so let's look at this. A practitioner or another person. So it doesn't have to be a practitioner. So it catches other people. Whether or not the other person is acting for the law practice. So you don't have to establish whether the other person who's doing this is acting for the law practice. Advertises personal injury services if the particular practitioner or person publishes or causes to be published a statement that may reasonably be thought to be intended or likely to encourage or induce a person to make a claim for compensation or damages under any act or law for a personal injury. Okay, so that you can see that provision there, make a claim for compensation under any act or law for a personal injury. It's not necessarily the claim with the solicitor's firm that's being advertised. It doesn't have to be that. Because if you look at the next provision, or, see it's or, it's not and, or to use the services of that practitioner or a named law practice in connection with the making of a claim mentioned in paragraph 1. So you can do this if you just happen to be somebody that posts up an ad or on a telegraph pole and says or encourages somebody to make a claim for compensation or damages. So it's pretty broad, isn't it? So why do we have this? Why can't people put up posters and things encouraging people to sue left, right, and centre? What's the rationale for this to exist?
I think it's to take it away from a real capitalist type of approach where we're clogging up the courts by giving people hope when it's not necessarily realistic.
Maybe, but go back, look at the year 2002. What was happening in 2002 and around about in the years leading up to 2002?
Tort law reform.
Tort law reform, and what was happening with insurance?
Going through the roof.
It was going through the roof. No one could afford insurance. So that put the Parliament in a position where something had to be done. So how do you make insurance more affordable?
Reduce the premiums.
Yeah, but how do you reduce the that's right, but how do you reduce the premiums?
They want to
Ensure
make
that
sure
cases that
people
go
use
to
it.
the court.
You reduce the number of cases going through the court and reduce the sort of outcomes that they're likely to achieve. Because you see, that then reduces the exposure of the insurance companies, who can correspondingly then reduce the premiums because they are not likely to have to pay out as much money. So this is why we start to see these sorts of provisions. This one is really trying to reduce it's interesting, isn't it? It's reducing awareness of potential claims or rights. It's almost counterintuitive in some ways, isn't it? You'd think people should be aware of their rights and their ability to bring an action to recover damages if they're injured. Yet we have the government doing the exact opposite. And the reason is because of the insurance problem. Okay, so that's that part of it. Then a business card isn't an advertisement. It's published by the practitioner within the meaning of Section 64. And then Section 65 outlines allowable publication methods when advertising personal injuries. So these are allowable things. And then you've got 65.2 says, however, each of the following is not allowable. And look at this one. Display of the statement on any printed document gratuitously sent or delivered to a hospital or left in a hospital or on any vehicle in the vicinity of a hospital. And that's what's a problem for Murray Stack and his approach.
So is it technically just kind of an outright ban on it? Like the loopholes
No,
are
it's
really...
it's not an outright ban, because what Section 64 does is telling you what the meaning of advertising is. Okay. And then in Section 65, it says these are the things you can do. So you can have a printed publication, you can have an internet website, you can have an internet directory, you can have a public exhibition such as a billboard or sign, as long as it's not exhibited in or on a hospital or medical center. So you can't put your sign on the hospital or a medical center. Printed flyers you can have that are sent or delivered, printed documents, receipt, a record in relation to a transaction. So if you give a if somebody employs your firm and you give them a trust account receipt or some sort of receipt that has your services on it, that's not an offence. But 65(2) says these particular things are not allowable as publication methods. Okay, and there's a list of them, but the one we're looking at was the hospital one. What about a sign across the road from a hospital? So it's not, just look at the wording. So you can't have a public exhibition on the statement in, well, across the road is not in, or on. Well, it's not on the physical hospital, is it? It's across the road. It's not sent or delivered to the hospital or left in a hospital or on any vehicle in the vicinity of a hospital. So provided you don't put your sign on a vehicle in the vicinity of a hospital, you could have a sign across the road from the hospital.
If you read it textually, yes, but if you read it, what's the purpose behind it? Potentially that's where you'd run afoul of it.
Yeah, it's not clear, really, is it?
Has the word vicinity ever been defined?
Oh, may have. I haven't looked at that, but you've got to read that in. So okay, so you're reading in the vicinity of the hospital attaching to delivered or left. Well, it's not delivered in the hospital or left. That really, to my mind, attaches to the vehicle.
Mm.
So if we had an ambulance with our sign on it and put it across the road from the hospital, I think that would definitely be a problem. But, it's a bit more difficult if it's a sign on a building or on a bus shelter, for example, outside a hospital.
Well, you could play worms and put it on two vehicles, split it across.
Well, it says on any vehicle, so I think that would cover two vehicles.
Well, vehicles, yeah, injury lawyer, name on another vehicle.
Oh, I see. You're splitting the wording across vehicles. Oh my, you're going to be a fun person to deal with in practice, aren't you? Yeah, that's interesting. But anyway, look, the point of this is just to familiarise yourself with the actual advertising rules. All right, what about the migration services one? What's the problem with that one? So we've looked at the issue of the business card for the hospital. That's a problem. But what about, that's in relation to personal injuries, but what about migration stuff? It's not a personal injury, so it's not going to fall foul of this issue.
I think it goes down to kind of the false, misleading or deceptive impression part of the solicitor conduct rules.
That's right.
Where it's kind of like you're conveying that you have a expertise of some sort in a field, which you do not actually have that particular expertise.
That's right. So it's a false and misleading statement. So we go down here, that's the rule you're referring to, 36. Solicitor of law practice must ensure that any advertising, marketing, or promotion in connection with the solicitor of law practice is not false, misleading or deceptive, or likely to mislead or deceive. And here's another one. Solicitor must not convey a false, misleading, or deceptive impression of specialist expertise, and must not advertise or authorize advertising that includes the word accredited specialist. Now, what's that about? What's this notion of accredited specialist? Because there's actually a lot more to that aspect. Does anybody know?
Well, to actually specialise in a field in law, you actually you have to prove competence in that field and be accredited by Queensland Law Society.
Yeah, no, that's certainly true generally, but there's a more specific situation. The Queensland Law Society and other law societies around the country run specialist accreditation courses. And these are courses that people study for, and you have to have a certain number of years of practice. And what it says, and they run courses in areas like, let me think, family law or property law, different sorts of areas. And so you can become an accredited specialist, say in wills and estates. And that term accredited specialist is a particular, it's like a badge that you get that signifies that out of normal practitioners, you have a particular specialty that's recognised by the Law Society. So that's why that provision's there about this notion of accredited specialist. So you can't have solicitors, for example, who don't have that specialist accreditation saying that they do, when others have got additional training and years of experience in that particular area. It's things. It also includes within the special accreditation, you've got, for example, a third of your whole practice has to be in that particular area, not generally. So that's what that's about. It's a slightly different thing. There's also potentially the Consumer and Competition Act, the Commonwealth Act as well, might be well and truly relevant to this as well. So there's also oppression and harassment. I'm not sure. Well, it depends on how Murray went around distributing his cards, whether that's harassment in terms of migration services, but we don't have enough facts about that. All right, I'll stop sharing that for a second. Let's move on to the next one. Providing 10% finder's fee to nurses and ambulance staff whose actions result in a new client for the firm. What about that? That sounds a good strategy, doesn't it?
Sounds like criminal conspiracy.
A criminal conspiracy.
Well, because
it certainly
if
sounds
the nurse,
dishonest, but is it a criminal conspiracy? I don't think it's
well, the way that's worded, it kind of says that the nurse's actions directly resulted in the ability for the client to make a claim.
Not necessarily make a claim. It's to engage the services of his law firm, who can then make a claim if there is one.
I'm just reading the question differently.
Yeah, but it's not a criminal. It's not a. There's no. Is there a crime in that? I don't.
It'd be like a fraud, wouldn't it?
It's not a fraud.
It's a kickback.
It is a kickback.
A bribe?
It would generate a problem for the nurse and the ambulance staff in terms of their employment contract with their employer. I think that would be certainly a problem.
There are specific provisions in the Personal Injuries Act that prevents this. Yeah, 67(1)(b), no touting, and 68(1), you must not give someone a cut for inducing new clients.
That's right. There is a specific prohibition, mainly in Section 68, and a 300 penalty unit fine. Again, a person must not pay or seek payment of a fee for soliciting or inducing a potential claimant to make a claim. So that's a penalty against the nurse, against the ambulance driver, and against Murray. Catches all. Well, no, it says, I'll put it up. It's easier for me to actually just put it up and then you can read it. Where are we? Screen share. Does it catch all three? Maybe not. A person must not pay, so that would be Murray if he paid it, or seek payment of. So that's if a nurse or an ambulance person sought payment of a fee from Murray, so I could catch them that way, for soliciting and inducing of a potential claimant to make a claim. Then it has this sort of escape provision. Don't commit the offence against subsection 1 only by, if the person is not a law practice or a person acting for a law practice, advertising in the ordinary course of conduct of the person's business. So if you're legally advertising, you're not going to get caught by that. If you're advertising in the hospital, it would be, but just normal advertising without catching those other rules, that's not a problem. Or if the person is a law practice or person acting for a law practice, charging a potential claimant a fee for professional services provided to the potential claimant as part of making a claim. So you are entitled to claim a fee as part of the process of making a claim. So that's not caught by it either. So that's basically your normal charging process. So they had to exclude that. So a couple of other things I've noted there: hospital workers, they're a prohibited person and not, are prohibited from providing patient details. So that's a problem as well. And then you've got the Australian Solicitors Conduct Rules themselves. There's a few provisions there. 12.4.3, receiving a financial benefit from a third party in relation to any dealing with the solicitor represents a client or from another service provider to whom the client has been referred by the solicitor, provided the solicitor advises the client that a commission or benefit is or may be payable to the solicitor in respect of dealing or referral. So this sort of captures if there's a referral process going on. So there's a few things there, but the main one is this provision in section 68 of the Personal Injuries Proceedings Act. Sorry, Steve, you mentioned another provision in section 67, I think you said.
Yeah, that's what I have written down. I don't have the act in front of me. A 67(1)(b), I think, was no touting for persons who were involved in an incident.
Okay, I just put a note in here. So
Yeah.
67(1)(b), was it?
Yeah, yeah.
I'll just highlight that because I'll give you this guide, but I'll just check that provision out as well in case I've missed that. I think you said no touting.
Yeah, the primary one was 68, but I thought 67(1)(b) may have touched on it too.
Yeah, all right. Well, I'll add that in. I'll check that out. All right, what have we got then? We go back to the next one. What's the next? Number 3. Yeah, I'll have to speed up a little bit. Placing a sign on a bus shelter on the main road outside the local hospital, which reads, injured, get stacks for your trouble, free initial consultation, phone that. Well, that was really that issue we were talking about earlier, that potentially you might be able to get away with something like that because it's not in or on the hospital. So that may be okay. As long as it's not on a vehicle. Brings you back to the good old days of statutory interpretation, this, doesn't it?
Could be argued, though, that the get stacks for your trouble could be misleading.
Possibly, I suppose. I mean, it can be read several ways, can't it?
No pun intended.
Yeah, maybe you could run an argument like that. But anyway, it's certainly not a breach of the Personal Injuries Proceedings Act, section 66, which is the main point. Okay, what about this one? Murray having a 1-hour talkback spot on the local radio advising on legal issues and commenting on the outcomes of cases in the local court. What about that? Okay, we've got 1 thumbs up. What else? Are people happy with that? Yeah, I think that's okay.
I think I read a case in the textbook, though, or something about how you have to be careful making comments.
You do have to be careful that you're not advertising personal injury services so you don't breach the provisions of the Act. But if he's just commenting on other cases and the outcomes of cases, advising on legal issues, and he's not, saying, hey, I'm a personal injuries lawyer, come and get stacks for your money, he's probably safe. But he needs to watch what he says. But
so you can't have a plug on that radio. That would be a breach of the Act.
Well, you have to look at what the actual provisions say. You have to have, well, firstly, is it advertising under section 66(1)? So potentially it would be if he plugs himself, it could be advertising. Is publishable by an allowable publication method? Is it an allowable publication method? Probably isn't. It is an allowable publication method, the radio. So, I would have thought he would probably be okay with that. All right. Sending brochures in several languages to all Australian consulates around the world, indicating Saxton law firm's expertise in migration services. Murray thinks he can brush up on his skills in the area or hire a new staff member to deal with the clients that arise. And it has a link to his website. Well, we've already sort of talked about that one, haven't we? It's not a service that he has. So it's a false and misleading statement. So advertising that's false and misleading, so that's a problem. Okay, visiting legal studies classrooms at local schools, lecturing students about their rights and handing out mouse pads with the phrase, need legal help, one click and get stacks. What about that? That's okay as well. Okay, it's an allowable publication. It doesn't seem to breach the Act. Is it dishonourable and disreputable? Probably not. Okay, what about this last one? Placing a large advertisement on the side of his van with flashing lights to attract attention. What about that? And this is a real life example that goes up and down the street. What do you think?
Well, firstly, it would depend if the light was legal, because if it looked like an ambulance or a cop car, you might be in a bit of trouble. And I think it would be okay as long as he didn't go in the vicinity of a hospital.
That's right. That's right. And I know that the lawyer actually does this, has had it vetted by the Law Society, and it's been approved. And I'm also reliably informed that it's a very effective advertising mechanism. So you see this thing parked on the side of freeways and all over the place. So it's a very cheap form of advertising, and it's quite effective apparently. So, but
isn't there also a concern around distractions?
Well, I mean, it's pretty
driving.
There's signs and things everywhere. I mean, I think you'd be hard pressed to win that one.
Because don't you also have certain standards for signs when they're placed on roads?
You'd be looking at council bylaws.
Yeah.
Well, for council roads, and then main roads is a different set of rules. Again, there's different bodies look after different roads. So you can look into that.
You complain about it as well for anything to happen.
Yeah, well, nothing's happened. It's been going for years. So, and I know that the particular person checked it out with the Law Society, and there was no problem from their perception, from their perspective. So it's interesting though, isn't it? Because it's a very competitive market. So advertising is part of the market. So there are rules, and you need to, I hope what you get out of this is you need to be familiar with the rules in terms of what you can and you can't do. But at the end of the day, if you want to run your law firm, you need to attract clients, and advertising is part and parcel of that. All right. Any general questions at this point? We've come to the end of our time. All right. Well, I hope you feel the subject's interesting. It is interesting.
I've got an interesting one for you. What are your thoughts on, say, a politician who may have been critical over judicial decisions in the past, then going and studying law and becoming a lawyer?
Well, I mean, politicians, part of their job is to critique all sorts of things. So I think anybody can pass opinions on judicial decisions. Certainly while they're a politician. When they become a lawyer, they then become an officer of the court. So they might have to be a bit more circumspect, but you can certainly comment on whether you think a decision is correct. And we do that all the time. You do that all the time as well when you're reading the cases, whether you think something's right. Whether something's right also changes in terms of the age of the case and the environment at the time. So, cases get overturned. And so, as long as you're not disrespectful to the judge, or the court, you can certainly critique decisions. So I don't really think that's necessarily a problem. We'd all be out of business. We'd all be sitting mute, and we wouldn't be able to, bring appeals, because we can't bring an appeal because the first judge was right. So, yeah. Right, other questions? You all happy? All right. Okay, well, I'll see you next week. Don't forget to join a group. So go on to the unit site under the assessment tile and make sure you join a group, and look forward to seeing you next week and see what we can discuss then. Okie doke. All right. Bye.